my larger question tonight is, and Abhijit Iyer-Mitra, I want to ask you two questions. Number one, why are people seeing religion in a case which is a case of national security? It is a case of riots. 53 people lost their lives in these riots in 2020. And we are discussing religion of the accused. We are discussing whether the Supreme Court is communal, the government is communal. When the judgment is of the Supreme Court, why is the government being called communal? Number one. And number two, the question I want to ask you, have you ever seen foreign nationals actually getting into what courts have to decide? And was this just a coincidence that Mamdani raised this issue just around the time the courts were to reopen and pronounce the verdict? Just like there was forum shopping earlier, something the former Chief Justice has himself said in this case. Is this now pressure tactics also, which this entire ecosystem wanted to build up?
Right. So you've asked me a bunch of questions, Nambika. Thank you. I'm going to answer them sequentially. The first is the notion that an intellectual somehow can't become a terrorist. The biggest mass murderers and psychos of the 20th century were great intellectuals. The biggest revolutionary of the 20th century was a chap called Mao Zedong, who killed 70 million Chinese people. Another great revolutionary intellectual was Stalin, who killed about 30 million of his own people. You want to take right-wing dictators? Antonio Salazar of Portugal was the head of the Department of Economics of the University of Coimbra. So please don't tell me intellectuals don't commit murder, don't commit riots and things like that. In fact, they are much more prone. They are much more insidious in the way they commit riots, number one. Number two, I have never supported the incarceration of Umar Khalid. I still don't. Sharjeel Imam is a different case. Like we've discussed, he transcends the Brandenburg definition, which is the American definition, which is a specific method against a specific target. Chakka jam at the chicken's neck, specific method against a specific target. There is no way he would get bail even in America, number two. That said, Umar Khalid either needs to fire his lawyer because the lawyer has gone down a very, very dangerous path. He has decided, for whatever reason, we will continue postponing this, not ask for bail for the last 4 or 5 years, keep postponing the bail hearing, keep postponing the trial, going on seeking to delay the trial. It almost seems to me that the lawyer himself is signaling to the court that his client is guilty. Now, if Umar Khalid is very confident, he needs to find different representation. The state cannot be held liable for inadequate representation of Mr. Umar Khalid. Third, one of the biggest tactical mistakes has been the way Umar Khalid's team has disclosed this letter that 8 lawmakers and Zoran Mamdani have written. Why? Because they have actually proven what the Supreme Court said today, that their complicity, Sharjeel and Umar's complicity, was at a higher level. Otherwise, why would 8 lawmakers and a mayor of New York be writing? They never found it prudent to write about Gulshifa and all those other 5 people that got bail, but they felt it very necessary to talk about Umar Khalid and only 8 lawmakers and the mayor to write about him. Zoran Mamdani, curiously, is saying exactly what the Supreme Court is saying, that you're much more important in the scheme of things. And that is why I wrote about it. Next, I want to point out certain remarks have been made about Kapil Mishra and Anurag Thakur. The case against Kapil Mishra is an election commission case. The hate speech is not linked to the Delhi riots. It is violating the model code of conduct. But good points on how they are trying to confuse the two of us. I am going to quote from the Mao Zedong of Mount Road, Madras. It's a magazine called The Frontline. I don't know if you've heard about it. We call it the Mao Zedong of Madras. The Sessions quote, and they're talking about Kapil Mishra here. This is the article. I'll hold it up here so that you can see I'm not fabricating.
They're not here to defend themselves, but...
The Sessions Court upheld the summoning order on March 7th, noting that Mishra's alleged statements appear to promote religious enmity by indirectly referencing a country often used to denote members of a particular religion. His speech was about Pakistan. Now, I'm not saying this. Frontline, the Mao Zedong of Mount Road is saying this. Imagine. Next, when it comes to this slogan, Desh ke gaddaron ko, I am merely going to, if you permit me 2 minutes, I am going to read out section 121 of the Indian Penal Code. Since that is now infractuous, I'm going to read out BNS section 147 and then section 163 of the Armed Forces Act. Section 121 Indian Penal Code. Waging or attempt to wage war or abetting waging of war against the government of India. Whoever wages war against the government of India or attempts to wage such war or abets the waging of such war shall be punished with death. This is IPC 121. BNS section 147. Whoever wages war against the government of India or attempts to wage such war or abets the waging of such war shall be punished with death or imprisonment for life and shall also be liable to a fine. Section 163 of the Air Force Act, which is also of the Army Act, in awarding a sentence of death.
What's your point?
His point
You
is
see the
Congress
point
makes
right
such
now.
people
A
leaders.
court-martial
punish them with death.
Here, please, Navika.
A court-martial, one second. A court-martial shall its discretion direct that the offender should either suffer death by hanging
Yes.
from the neck or by being shot to death.
Absolutely.
Kapil Mishra and Anurag Thakur were quoting from the Constitution. These people hate the Constitution.
Sanjay Jha respond. Sanjay Jha respond.
Navika, there are 2 points I wish to make, and I think your viewers need to know. Ladies and gentlemen who are watching a very popular program, Umar Khalid's trial has not even started. He's not convicted, by the way. The trial is actually not even commenced in a proper sense. He's been there for over 5 years. A rapist, a convicted rapist, is out on parole for the 14th time. You need to know this, ladies and gentlemen, to know where India's criminal justice
Fair
system
point,
is.
fair point,
It's a shame.
obnoxious,
It's a shame.
obnoxious
No,
that
you
Ram
can't
Rahim
answer
goes on
this.
parole
Give me
for 420 days.
line.
But are you comparing this with somebody trying to cut the chicken neck and separate
No, I'm not.
Northeast? Are
No,
you
I'm
trying
not,
to compare
Navika.
these two things, Sanjay Jha?
Navika,
Because
I'm
if you
going to-
are,
I'm going to quote you
I
the
think
quotes.
you are speaking a language that you shouldn't.
Courts. Look at what the courts have said in the riots case. It is very important that your viewers know. The courts have accused the Delhi police of fabricating evidence, of fake witnesses. In 2 cases, police have dictated the content.
You believe the courts in that case, but you don't believe the courts when they give this verdict of denying bail to Sharjeel, Imam, as well as Umar Khalid and Ishkaran Bandari. That is where I'm coming to you. But Ishkaran Bandari, that's where I come in. They want to do forum shopping. They want to do shopping of the kind of orders that suits them. They will turn a blind eye to the other facts of the case, and that is exactly the narrative and the blueprint that they want to hand over to other countries. Is that not true?
Fake evidence, fabricated witnesses by the Delhi police reporting to Amit Shah. That's a serious matter.
Cherry picking of
That's a
1
very
second. It's a
serious
question
matter.
to me, Sanjay. It's a question to
And
me.
these are the
It's a
courts
question to
saying
me.
it,
You
not
had your
me.
turn. Can I make?
Sure,
It's
go
a
ahead.
question to me. Can I have my turn now? You had your turn. Have some discipline.
Yeah, go
Please
ahead,
have some
man.
discipline.
Go ahead.
You
Yes,
had your
please.
turn. Nobody interrupted you. Navika ji, the cherry picking of one case versus the other. Can I speak now? Navika ji, the cherry picking of one case and against another case. Firstly, even the most heinous of personal cases in the sense of murder has no comparison with a terrorism case. But secondly, the law on parole and furlough is very different and it can always be challenged if it's been wrongly given. Third, the bail in a terror case has to be dealt in how a terror case is dealt with. So let's stop this penny checking that if one accused is out, the other accused is not out. Even in this case, there are certain people in the Delhi riots case who have got bail. These people's role, and the court consciously goes into the role of the individual. Why are we not talking about what is the role of individual?
That is the
influence
point,
and how
Shehzad
involved
Poonawalla.
is